Hey everybody, I am here as promised to bring you this hearing covering James and Jennifer Crumbley. I wanted to give you an update just because things are moving in the case with their son, Ethan Crumbley. He just had his Miller hearing, and the judge in his case is set to decide whether he's going to either get life without parole or life with parole, and that should be in September of 2023. So I wanted to just catch people up to date if they didn't know what was going on in his parents' cases, because um, it's pretty new. It's a new thing where the parents are being charged in the case of a mass shooting. This has never happened before in the United States. So this is the first case, so this may be interesting to some people. So just wanted to bring you up to date to what's been going on, pretty much covering the last 6 months. So the first thing I want to do, of course, is give you a good foundation because we have to know the law, right? When we're talking about legal matters, we need to know what we're talking about. So the first thing I want to cover is what is involuntary manslaughter. So, in the case of Ethan Crumbley's parents, they both were charged with 4 counts of involuntary manslaughter. So, we kind of need to know what that is, right? That is the lowest crime of a death. So, you would have first degree murder, second degree murder, and then manslaughter. And that would either be voluntary, which means with knowledge, with action behind that, or involuntary, where you actually didn't do it, but your actions or inactions caused the death of another. But let's hear what Black's Law Dictionary has to say, right? Let's get the legal terms from here. So, involuntary manslaughter is a homicide in which there is no intention to kill or do grievous bodily harm, but that is committed with criminal negligence or during the commission of a crime not included within the felony murder rule. It's also termed negligent manslaughter. Okay, so let's just go over this other term, this other legal term, and they're posted on my Facebook page if you want to review that, which is the term of criminal negligence, because that's within the definition of the manslaughter, that there has to be some existing negligence. There's a death, but you're being tied to that death, even though you didn't cause that death, you were not the actor, the assailant. You're being tied to that death due to some type of negligence, right? And that's what they're alleging in this case with James and Jennifer Crumbley. So, criminal negligence. Criminal negligence, the gross negligence, so extreme that it is punishable as a crime. So, it's saying that the inactions is so extreme, something that should have happened, you should have intercepted, you should have been able to prevent it, is so bad that it's considered a crime what you did. So, it's negligence, but it's gross negligence, right? It rises to the level of a crime. Now, um, in Black's Law Dictionary, they love giving examples, they love giving details. So here they give an example. So it says, for example, involuntary manslaughter or other negligent homicide can be based on criminal negligence, as when an extremely careless automobile driver kills someone. So they're giving you the example of an auto accident, which is fairly common for somebody to be charged with involuntary manslaughter or negligent homicide. They kind of interchange those, but for the example that they're giving, you can be driving and you could be under the influence of alcohol or drugs. You hit someone, you're not intending to hit them with your car, but you hit them. They pass away. at the level, would it rise to first degree murder? No, because first degree murder has to show that there's some premeditation, that there's some planning. You didn't plan it when you were drunk driving. You didn't intend to hurt anybody, but you did. Would it be second degree murder? No, it doesn't rise to second degree murder either, but it would fall under that involuntary or negligent homicide, where you're not trying to do something, but you're negligent. The fact that you're driving and you're under the influence and you have an accident and you cause the death of somebody else, that's what it would fall under. Okay. Okay, so those are our terms. So manslaughter, involuntary manslaughter, and criminal negligence. Those are our terms for today. So let's talk about the Crumbleys, and I'll just catch you up to kind of what's been going on. Now, when the incident initially occurred, I'm kind of surprised that we're lapping almost 2 years. November 2023 will be 2 years that the shooting happened at Oxford High School, right? So we're in a situation where James and Jennifer Crumbley were Ethan Crumbley's parents. They've been married and they were living in Oxford. And of course, Ethan was attending Oxford High School. He was a student there. And from the court records and documents, Ethan was having a lot of issues. Some of the issues were his parents were not really being responsive. So he would be texting them, hey, when are you coming home? Where are you at? I don't like being alone. He would be seeking them out for their attention, for them to be home with him. And for the most part, they either were not responding to his text messages or not returning his calls. So that left him alone quite a bit. Both his parents worked. His mom had some employment in real estate, and his dad worked for DoorDash at the time. So they both had jobs outside of the home, and then Ethan is their only child in the home, and he was in high school. He was 15 years old at the time of the shooting. Prior to the shooting, Ethan pretty much didn't have a lot of friends. At some point, he had the death of a grandparent, and his dog also passed away. Another situation that was highlighted with his case was during the same time period, he had like a best friend that moved away also. So he was kind of struggling, and he had came to his parents on multiple occasions asking for help, expressing to them that he was hearing voices, that he thought a demon was in the house. He just was expressing the need for attention. You know how kids can be at times. They want your attention. They want some time with you. They want face-to-face time. They want to do things with you. They just want to know that you care, and that they're spending time with you and seeing you, right? So that was kind of what was happening with him. It would be periods where his parents would not respond to him in text messages, and he'd say, can you at least respond to my text messages, at least so that I can know you're hearing me, you're there, because they weren't at home with him. A lot of times they would be in other places. They would be out. They had a horse, so they would be out riding their horse or checking on their horse, or they would just be out. They wouldn't respond. It could be a day or two that go by. I guess maybe they had some nights where they didn't come home at all. But at a minimum, he was feeling alone. It appears that he was feeling lonely, maybe sad. And he would, through messages through other people, friends, people that he met, he would be expressing to them that he was feeling like he had a mental breakdown, that he was struggling in his thoughts. He had even mentioned wanting to talk to his parents about just going to see a therapist. He told one of his friends that they didn't want to take him to a therapist. They weren't going to do that. That his mother said that she thought he wasn't having a mental breakdown. She thought he was using drugs. So what was happening when they weren't there, a lot of things was happening in the house. Things was falling. You know, he would say that it was a demon in the house. He would say that things were moving in the house, that he heard sounds, just different things. And I guess he expressed a lot of his feelings in a written journal. And throughout the pages of the written journal, in every page or on every page, he was writing about doing a mass shooting at the high school. Um, Overall, that was what he was going to feel, that this mental breakdown that he was experiencing, it all was leading him to do this mass shooting at the high school. Once he got access to a gun, as a Christmas gift, his parents purchased him a gun, and he then used that gun to um, have a shooting at the school, to cause a shooting at the school. So that's just a little bit of a background. So this is the first case in the United States where parents are being charged for the acts of a different person, their child, their son. In his case, 4 students were killed in the shooting at the high school, at Oxford High School. So we're looking at a situation where the parents are being charged with 4 counts of involuntary manslaughter for the killing, even though they were not involved. There was enough evidence to the prosecutor to feel that the parents were extremely negligent, and they charged them with 4 counts each of involuntary manslaughter. So that's the basis for our conversation today. That's what we're talking about. We want to bring everybody up to date with what's going on. When they were charged, both James and Jennifer Crumbley, they decided to take their cause up and appeal it to the Michigan Court of Appeals. They felt that there was no history, there was no past evidence where parents were being charged for the actions of their child. So that was clear that this would be a new precedent, that they could be charged even though they did not commit these acts. But again, we know what involuntary manslaughter is, right? We know that it's some criminal negligence there that rises to the point where your inaction is a form of negligence and you can be charged. It just had never been charged in the United States. So these are the first 2 parents to be charged with involuntary manslaughter tied to a mass shooting in one of the high schools in the United States. So that's why we're talking about it today, because it will set a legal precedent. If the Michigan Supreme Court allows this case to go forward, because they did file requests that they review the case. So let's talk about all of that. So we're going to go to 2 articles. The first one being in the WXYZ Detroit website. The article is dated May 18th, 2023, and is titled "Attorneys for James and Jennifer Crumbley Appeal to Michigan Supreme Court in Oxford Case." So that's the first one we're going to listen to. Okay. Well, I will read this, and then there's going to be about a 2-minute video. So if you're online, you can follow along, or you can just listen or refer to it later. So let's go, you guys. The attorneys for James and Jennifer Crumbley have filed appeals to the Michigan Supreme Court after the Michigan Court of Appeals ruled in late March that the couple can stand trial in connection to the deadly Oxford High School shooting. James and Jennifer, the parents of Ethan Crumbley, who pleaded guilty to the shooting at the school that killed 4 students and injured 7 other people, are each charged with 4 counts of involuntary manslaughter. The charges stem from the deaths of Madison Baldwin, 17 years old, Justin Schilling, 17 years old, Tate Murr, 16 years old, and Hannah St. Juliana, 14 years old. They were killed by Ethan during the shooting at Oxford High School on November 30th, 2021. 7 other people, including a teacher, was also shot and injured. In February of 2022, a judge bound over James and Jennifer after a preliminary examination, saying there was enough evidence for them to stand trial. However, their lawyers appealed the ruling, and in November of 2022, The Michigan Supreme Court issued a stay on the case and sent it back to the Court of Appeals. In the opinion released on March 23rd, the Michigan Court of Appeals noted that the district court didn't abuse its discretion, saying that the gunman's decision to shoot his classmates was not a superseding cause because it was foreseeable based on an objective standard of reasonableness. Defense lawyers argued that the case might set a precedent where parents could be charged for violent acts committed by their children, but the Court of Appeals argued those concerns are significantly diminished by several well-established principles. In yesterday's filing with the Michigan Supreme Court, the Crumbley's attorneys say the Court of Appeals decision is clearly erroneous, will cause injustices and conflicts with Michigan Court of Appeals and Supreme Court precedent. In October of 2022, Ethan Crumbley pleaded guilty to 24 charges, including 1 count of terrorism and 4 counts of first-degree murder in the Oxford High School shooting. I'm going to play a quick video. It's only 2 minutes, and then I'm going to go a little bit deeper into what the Court of Appeals said, because this is a great article. It sums it all up, but I just want to go into a little bit deeper what the Court of Appeals said. And I actually have some legal stuff, but I'm not sure how to post it because it's 17 pages long. It's quite long. So let's check out this video. It's about 2 minutes long.
It's the final chance for the parents of the Oxford High School shooter to have charges against them thrown out.
They have now appealed to the state Supreme Court in their case and have been locked up since December of 2021. The Court of Appeals has ruled they must stand trial for involuntary manslaughter.
7 Action News reporter joins us from Pontiac, where they
I'm sorry, guys. I might have to reload the page. Oh, no, okay. I had paused the video. So it's reloading now. Okay. So let's see if we can get some sound.
chance for the parents of the Oxford High School shooter to have charges against them thrown out.
They have now appealed to the state Supreme Court in their case and have been locked up since December of 2021. The Court of Appeals has ruled they must stand trial for involuntary manslaughter.
7 Action News reporter Simon Shaquette joins us from Pontiac, where they are still behind bars. Simon.
Here at the Oakland County Jail, Jennifer and James Crumbley remain behind bars as they make one final appeal to the Michigan Supreme Court to have the case against them dismissed.
I believe that those parents could have done something to change this outcome.
Oxford parent Stacy Broder reacting to the last-ditch effort by James and Jennifer Crumbley to avoid trial in the deadly school shooting committed by their son, Ethan Crumbley. The couple has already lost appeals to the Circuit Court and Michigan Court of Appeals.
The hardest part is the waiting, right? I guess I personally take delight in the fact that they're still in jail.
The first parents to be charged with involuntary manslaughter in a mass shooting. Following the tragedy in November 2021, their attorneys have argued they are not responsible for their son pulling the trigger and could not have known what might happen. Yet their 15-year-old son has admitted his parents bought him the gun he used to kill 4 students and injure others, and his parents also allegedly refused to provide Ethan with mental help.
The trauma that all of our kids have went through, nothing is going to make that stop.
Parent Carrie McCarthy says she's hoping to see the Crumbleys stand trial.
I think us Oxford parents, nothing is ever going to bring our children back, and us getting some form of answers, it will help to start to be able to heal.
I think people can go forward and heal once things are settled. And right now we aren't healed yet.
Both sides in this case are still barred from talking to media by the judge. The next step in this process will be the prosecutor's office being given 28 days to issue a formal response to the Michigan Supreme Court.
Okay. So I just want to go over a little bit more detail from what was being said in the article. So I'm going to read. I'm going to read a little bit. I'm going to read a little bit from the decision of the Court of Appeals. So I'll just pick up on page 10. Felony complaints against defendants were issued soon after their arrest, both of which allege that defendants' grossly negligent conduct caused the death of the 4 victims by storing his or her firearm and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent failure to perform the following legal duty, to wit, failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others, or from so conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and opportunity to do so. So it's kind of like 2 standards that the court is putting out there. One, they're really talking about how they stored the firearm and the ammunition. The fact that they kept the ammunition and the firearm together, that's one part of it. The other part is when they had the firearm, they didn't use like a child safety lock, something to secure it or to lock it behind something else, maybe a safe. The fact that he had access, that's one level, but the other part is that there was no lock on the gun and that the ammunition and the gun were together. So he needed both parts, both the gun and the ammunition, to, of course, shoot. So by them not taking any steps to properly store it to prevent him from having access, that's part of it. And the other part is also having the gun and the ammunition together. That caused him to be able to just take them. The other part of what they're saying, and that's the second part, is they had a duty to exercise reasonable care in controlling their son. So reasonable care would be if you know the mindset of your child, if you know their thoughts, their actions, the fact that he was feeling alone, that he was kind of suffering a mental breakdown, that he had expressed in so many different ways what he was going through, how he felt alone, asking them for help, texting them, can you please come home? Can you please answer my text message? Can you call me? Asking them to take him to a therapist. At every area, they did not exercise reasonable care. It wasn't things that they did not know were happening. He was going to both his parents at different times, and they refused. They refused to help him. They refused to provide him with any care. And when you're not exercising reasonable care, that will put you in a place where if something happens, like in this incident, a mass shooting, the parents may be looked at, right? So let's keep going, because this is what the Court of Appeals is writing. This is what they felt in this instance. After the conclusion of the 2-day preliminary examination, the district court provided its decision to bind over defendants as charged. So they're saying that they did receive a preliminary hearing, and a preliminary hearing, as we already know, that's going to allow both the prosecution and the defense to put on witnesses, to question witnesses, to put on evidence, right? To cross-examine. So they were given an opportunity to both put on witnesses, to cross-examine, to hear the prosecution's evidence against them. And the court's decision was to bind them over, right? Okay. The district court articulated its reasons for doing so. So when they binded them over, they said why. So let's hear why, right? Because that's important. We want to know the why. Therefore, in this case, after hearing extensive evidence, extensive testimony, as well as evidence and reviewing and viewing extensive exhibits. So they're saying this was a very well thought out case brought by the prosecution with extensive evidence, extensive testimony, and extensive exhibits. Okay? The court finds that the deaths of the 4 victims could have been avoided, right? We all know that, right? We all know their deaths could have been avoided, right? If they had found the gun earlier, if they had checked the backpack, if the parents had took him home, if they were able to take him directly as asked for, right? The counselor asked them to take him home to a therapist that day while they were at the school. The day of the shooting, both the parents were there. They asked them, they said, there is a need to take him to therapy. Can you do it today? The parents, more so Jennifer Crumbley, said, no, we both have to return to work. And the alternative was you have 48 hours, right? You have 48 hours to take him, get him into therapy. So we all know this could have been prevented. If one thing had changed, maybe we would have a different outcome, right? So let me go back to what the court is saying, because we want to kind of stress that. Therefore, in the case, after hearing extensive evidence, extensive testimony, as well as evidence and reviewing and viewing extensive exhibits, the court finds that the deaths of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in the care of their son. So this is clearly being placed as parents. Your son. They want the school to step in. They want the counselor to step in. They want security to step in. They want police to step in. But you were there, right? They were there at the school. They could have taken him. And if they had exercised what they called ordinary care, just like earlier in the paragraph above, reasonable care, to control your minor child, to prevent any harm to others. These are standards, you guys. These are things that they're going to apply them to these parents. And they're saying this is ordinary care. You didn't do anything extraordinary. You were at the school. That's all you had to do was take them. But they refused. They refused. Okay, let's continue. Specifically, the court finds that the prosecutor has shown by a probable cause standard. Remember, probable cause is the lowest standard. That she's presented enough evidence to get that probable cause threshold. It's not beyond a reasonable doubt. It's not the preponderance of the evidence. It's probable cause. So from the probable cause standard, that number one, the defendant's son, Ethan Crumbley, presented a danger to the community. He presented a danger to himself, but they're looking at the effects of how it will harm others, right? If you unalive yourself, that doesn't hurt anyone else. So they're looking at the harm to others. The fact that this person's mindset, it could have harmed himself, but they're looking at the effects in the community. And where does he go? He goes to a school, and of course you have hundreds of other students. So they're looking at the harm, the threat to others, not just yourself. So number one, the defendant's son, Ethan Crumbley, presented a danger to the community. Number two, that the danger was apparent to an ordinary mind. So they're saying that his actions, his behaviors, would an ordinary person believe that he was a danger? Him drawing those pictures, placing the gun, putting somebody shot, putting blood down. Would an ordinary person believe that this person could be a danger? They're saying yes. They're saying yes. Number 3, that the defendants, James and Jennifer Crumbley, neglected to diligently address and or divert that danger. Could they have done something? Could they have made a different choice? Back that March of 2021, when he was asking to go to a therapist, they denied him. They said no. They said they weren't going to take him. His mother said that she didn't feel that he needed therapy, that she thought he was using drugs. And he's saying, I'm having visions. I'm seeing a demon. Voices are talking to me. I need help. I want to go to therapy. Both his parents, they just did not respond in the appropriate way. So again, number 3, that the defendants, James and Jennifer Crumbley, neglected to diligently address and or divert that danger. The day of the school shooting, they were at the school that morning, the same day. I believe about within 10 minutes, his mother texted him and asked him, was he okay? And he said, yes, thank you. And then he went and did the shooting within 10 minutes. He went to the bathroom to take the gun and take everything out and did the shooting. Okay, let's continue on. Number 4, that the danger resulted in the 4 deaths of the young children at Oxford High School. And let's be honest, let's be clear about this. This is what I don't want to miss. If the administrators, if those teachers were not prepared, if they did not respond quickly, if the students did not respond when they came on the speaker system and said they had an active shooter, if those teachers did not lock those classrooms down, there would have been more people harmed and unalived. That's why he had to return to the bathroom, because there were no students in the hallways. The teachers locked the doors. They covered up the windows. He couldn't enter into the classrooms. That's why he went back to the bathroom. Remember, he exited the bathroom. He waited for the kids that were passing. Ethan had planned it all out to get the maximum number of people that he could shoot. He waited when they were changing classes. And he emerged from the bathroom and began shooting the students. There would have been a higher number of injured and possibly unalived students if those teachers, the administration, did not quickly act. And even the police, when they came swift, they came fast. We have to give them credit and acknowledge them for their good work. For their quickness and diligence in finding the active shooter. It's hard, y'all. It's hard. So yes, the parents, when they don't want to take any responsibility in this, that's a problem, because they were there. They were at the school that morning. If they had taken their son The school could not refuse him staying for the remainder of the day because he hadn't done anything. They were more concerned of his thoughts, and they thought that he was suicidal. Ethan was never going to harm himself. He didn't want to be harmed. He didn't want to be unalived by the police. He had already planned through his journal entries that he was going to surrender. He was going to shoot as many students as he could until the police came, and he was going to surrender. And he was totally aware that he would receive life in prison because of his actions. It's all in his journal. I have some of his journal entries on my Facebook Hidden Horror page. You can check them out. You can read them for yourself. Let's continue. There was an extensive testimony that Ethan Crumbley was certainly a troubled young man, and that the defendants had knowledge of that situation, but they purchased a gun which he believed was his and that he was free to use. Therefore, the court is binding the defendants over as charged. And it's something that I said in a prior video. This was a gun that belonged to Ethan. It was a Christmas gift. It was an early Christmas gift that his parents purchased. It was his gun. His mom took him to the gun range to shoot it. He posted pictures on his social media. His mom even posted some pictures on the social media about the gun. This was his gun. And with this mindset, the parents aren't thinking. They have a duty, right, to exercise reasonable care. If your child is having all of these mental issues, breakdowns, hallucinations, you're seeing demons, voices are talking to you, why would you place a gun in his hands? He's drawing pictures of violence. He's being caught in class searching for ammunition. And Jennifer Crumbley response is, you have to learn to find a way to get away with it, not to get caught in class. That's her advice to her son. Let's keep going. Before the circuit court, defendants filed a combined motion to squash the bindover, contending that the district court abused its discretion by finding probable cause existed to believe defendants committed involuntary manslaughter. In particular, defendants argued that the bindover had to be squashed because, as a matter of law, the prosecution could not prove causation. Though acknowledging that the issue of proximate causation, as opposed to causation in fact, hinged on whether Ethan Crumbley's independent criminal actions were reasonably foreseeable. Reasonably foreseeable. Defendants argued that the district court's reliance on Head and its ultimate conclusion were in error. Let me ask you, if your child had all of this going on, maybe you didn't know all of it, right? Maybe you just know on the surface. Maybe you just know on the surface the behavior, what the school is calling and reporting, the feeling alone, the sadness, the dog passing away, the grandparent passing away, him not having his friend live close anymore. Maybe you're aware of that, right? But when you purchase a gun, you give that child access. And is it reasonable? Is it foreseeable that they could use that gun to harm others? That's what they're bringing up, right? The circuit court issued an opinion and order denying the motion to squash, explaining why it could not accept defendants' causation argument. So listen to this. The court concludes that sufficient evidence has been presented to allow a reasonable juror to find factual causation and to allow a reasonable juror to conclude that the deaths of the victims were a direct and natural result of the defendant's gross negligence. The court further concludes that the criminal misconduct of the defendant's son was an intervening cause, but that a reasonable juror could conclude that his actions were reasonably foreseeable. Him shooting up the school was that foreseeable. He wrote it on every journal entry. When he had conversations with his friend, he actually discloses that he's going to shoot up the school. When he got the gun, no, I'm sorry, when he got his father had a different gun. When he had access to that gun, he took pictures and video, he talked to his friends, and he was saying he was going to shoot up the school. And his friend, no, you shouldn't do that. No, I'm just joking. So was it reasonably foreseeable? How does his parents how are they not aware of any of the things that was going on with their son? They're not aware partly, or they may not have been aware partly because they weren't around. They didn't respond to his text messages. They didn't return his calls. They didn't show concern for his son. So let's keep going. The court further concludes that the criminal misconduct of the defendant's son was an intervening cause, but that a reasonable juror could conclude that his actions were reasonably foreseeable. Therefore, the causal link between defendants' actions and their liability for the deaths of the victims, as alleged by the people, meaning the prosecutor, the state, in this case, the state of Michigan, is not severed by the actions of their son. A reasonable juror could conclude that the action of the defendant's son was a related link in the causal chain. And of course it was. So they said because the circuit court concluded that the district court did not abuse its discretion in binding over the defendants as charged, it entered an order denying the motion to squash. So now, James and Jennifer Crumbley, they have decided to appeal this ruling to the Michigan Supreme Court. So let's go here. I linked that article on the page. This article is from the Detroit News. It's dated June 27, 2023, and this is the title of it. Prosecutors offer new evidence of Crumbley's parents' consciousness of guilt to the Supreme Court, the Michigan Supreme Court. Let's go. And you can read along, or you can listen, or you can refer back to it. It's linked on the Hidden Horror Facebook page, okay? Oakland County prosecutors have brought new evidence to the Michigan Supreme Court of the consciousness of guilt by the parents of the Oxford High School shooter as they appeal their involuntary manslaughter charges to the state's highest court. Okay. Among the revelations, County Prosecutor Karen McDonald's office noted that James Crumbley took the receipt for the gun he had bought his son with him when he and his wife Jennifer fled Oakland County after the November 2021 shooting. James Crumbley had the receipt on him when he was arrested. So they're kind of insinuating that he was trying to hide the evidence that they purchased the gun. But gun dealers, they have records. They have to keep a record of every gun sale, every purchase made. They have videos, so they will be able to show, for example, the day of the purchase, who was in the store, who they did a background check on, because you have to have a background check done before you purchase a gun. So they would have a record of the background check. They would also have on the form, you have to say that this gun, you're using it for yourself. You're not purchasing it as a straw buyer, meaning you're purchasing a gun and then selling it or giving it to someone else, you have to check that. So you're acknowledging that this gun is for you, that you're not giving the gun to someone else, especially a minor. But okay, let's keep reading. Among the revelations, County Prosecutor Karen McDonald's office noted that James Crumbley took the receipt for the gun he had bought his son with him when he and his wife Jennifer fled Oakland County after the November 2021 shooting. James Crumbley had the receipt on him when he was arrested. Defendant's flight and the taking of the receipt for the murder weapon during such flight provide an inference of their consciousness of guilt, prosecutors wrote. Just what I said, okay? While the people are prepared to present additional evidence of causation, this court need not reach that issue because the evidence presented at the preliminary examination exceeded the low bar that is the probable cause standard. That's the lowest bar. And of course, they reached that. Prosecutors wrote. The prosecutor's office added that the Court of Appeals opinion is a narrow one that is consistent with the court's precedent. The Crumbleys are charged with 4 counts of involuntary manslaughter in connection with the mass shooting their son committed at Oxford High School on November 30th, 2021, which left 4 students dead and 6 students and a teacher injured. Prosecutors said the Crumbleys were criminally negligent and could or should have foreseen the shooting. Okay, we just defined what criminally negligent is. It's having gross negligence. The Crumbleys' attorneys, Shannon Smith and Marielle Lehman, have said prosecutors cannot demonstrate that a juror could decide that a reasonably foreseeable outcome of the Crumbleys' alleged gross negligence was their son committing a shooting that day. Well, that's not really making any sense because they were at the school the day of the shooting. And they knew they had already purchased a gun and he had access to the gun plus ammunition. So it's definitely reasonable. But okay. I don't know what just happened. My screen is black, so I'm not sure what just happened.